Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hello, everybody. Welcome to another edition of the Empowering Plans Podcast, now on video. Super excited. I'm a little under the weather, so my voice isn't normally as cool as it normally sounds, but bear with us here as we go over some awesome topics. I've got with me today Cindy Merrell. Cindy, say hi, introduce yourself, all that fun stuff.
Hi, Cindy. I am a managing attorney on the subrogation side, so I don't get to work with Brady as often as I would like, but I'm very excited to be here on our very first video podcast as well.
Yeah, we have a very exciting case to talk about. These podcasts give us an opportunity to kind of do a little bit of a deeper dive, as many of our listeners know. And this case we want to talk about today is the Lewandowski versus Johnson & Johnson case. It kind of spanned over the course of a year in terms of when it was filed and all the activity around it. And it was part of a trend in litigation being filed against plan sponsors alleging fiduciary breach for drug pricing. And others are out there about things like excessive fees. And this was a really high profile case, not just because of the employer involved being Johnson & Johnson, but it was a class action case. It was filed in federal district court in New Jersey. And the most recent news as of last month is that the court granted 2 out of the 3 requests of the defendants to dismiss the case for lack of standing on a couple of counts. So we kind of want to go over why that is and what happened. But before we jump into those fun parts, just some quick background on this case for those of you who might need a little refresher or maybe who are new to what happened here. But effectively, in the complaint that was filed by Mrs. Lewandowski and her attorneys, obviously on her behalf, she alleged that the plan benefits committee at Johnson & Johnson breached fiduciary duties through a number of their actions, which led to allegedly them overpaying for prescription drugs. So in the filing itself, they list a number of examples. They actually have it's like a detailed charts that they've attached to the complaint where there's 42 generic drugs where they show the price that the plan paid for those drugs versus the price that someone would pay off the street if they went to CVS without insurance. And yeah, there's a lot of egregious examples of the plan being charged a lot more money. And this is not something new to anyone listening to our podcast. One example they gave was a generic drug for multiple sclerosis or MS. The plan paid 250 times more than someone who would have walked into a large retail pharmacy and bought it off the shelf. And so the allegation effectively, no prudent fiduciary would agree to those terms. Basically failure to consider non-traditional PBMs as a solution here. The allegations they didn't negotiate adequately within the contract itself, and they didn't consider other alternatives like carve-outs for specialty drugs. So all those things kind of baked into the complaint. And regarding the issue of what was the harm that she alleged, right? Why was this person harmed allegedly? Well, it wasn't that her benefits were denied, right? The claims were paid, benefits were paid. Here she was alleging that she paid more in premiums, right, overall monthly because of the inflated price overall to the plan, that her premiums or contributions were higher monthly, that her out-of-pocket costs were higher than they should have been. And ultimately, which I think is an interesting one, that it led to depressed wages for everybody who was an employer of Johnson & Johnson or employee of Johnson & Johnson, that because of their failure to curtail specialty drug prices and generic drug prices, the employer wasn't able to pay people more, right? Kind of an interesting argument. And this case is kind of unique in a way because the plan here was funded by a trust, and a lot of self-funded employers don't use a trust. So there was, at least on its face, more of a record to sort of trace spending here and the costs. And so it looked like it was a good case for the plaintiff, and that maybe the employer here would be in some trouble and it could lead to some real reform. So Cindy, I don't know if you had any different impressions or wanted to add anything about what you saw in looking at this case and why it was interesting to you.
Sure. Yeah, no, I had very similar. I think that this is really a good one, the good timing of everything, because with everything going on with the murder of the United Healthcare Group's CEO, and there's lots of headlines, like little short snippets. People went in there, and on the complaint itself, it is pretty, when they're talking about a drug that somebody could get for $48 if they walked into a pharmacy at CVS, but that plan is paying a significant sum more, that grabs people's attention. And it really was one that the plaintiff's bar was thinking this is going to really lead to reforms. And this was touted as maybe the blueprint of pursuing those claims. So yeah, I had very similar impression, and it was very consistent with the current headlines and what's going on today.
Yeah, absolutely. Well, so ultimately, as we know, those of you who may have saw the headline last month, the case was dismissed for lack of standing. And standing is interesting because it's one of those legal concepts that you might have heard a little bit about in passing, but there's a lot of elements here to be met to meet the standards for standing. And before a court will even consider the merits of a case, right, they want to make sure that the parties involved have standing. So, Cindy, I've asked you to kind of come ready to talk a little bit about, for a non-lawyer audience, sort of what is standing, what are the standards generally speaking, and why is it an important part of what the federal courts do?
Sure. So we don't want, in order for somebody to bring a claim in court, they have to actually, there's actually a legal standard that he or she must have suffered an injury in fact, not a hypothetical, not potentially an injury, or they have to be able to demonstrate they've actually suffered a harm. And then they have to they have to prove that harm was actually caused by that party that they're pursuing that claim against, that litigation against. And then there's a third prong that the injury would be redressed, which means for non-lawyers, it means that it could be fixed essentially, or helped by the judicial relief, by the court could do something in that circumstance to fix the issue, to make the member, I'm sorry, I'm saying the member, the actual plaintiff made whole. So, but your thoughts on this one, on this particular case, because standing really was a big deal on that's how they got dismissed.
Yeah, and the three prongs that you identify with standing, they may seem straightforward even to people, trained as attorneys, but in many of the cases that we read going back to our law school days, it's actually surprising. You may think from looking at a fact pattern that, oh, clearly this standard was met. Clearly the injury was caused here by the defendant. But when you actually look more deeply in many of these cases, it's actually hard to prove the causation element. There's other things that come into play here that may make a case that seems on its face that it would meet the standards actually not to. So in this case here, I read through the court's opinion issued last month in which they dismissed some of these allegations, and what I'll just read you a little bit here from what I found, the notes I took. So Johnson & Johnson, of course, was saying the plaintiff did not allege a concrete harm or injury in fact. They were saying effectively that her allegations were speculative, that she couldn't actually prove that she was paying more in monthly contributions or than a similarly situated employee somewhere else. And so it becomes clear if you go through the court's opinion that there's some missing elements here. So with respect to the out-of-pocket claims, for example, interestingly, they showed that there weren't enough facts to show that the injury, in fact, was redressable. They actually thought that with respect to the out-of-pocket claims, the plaintiff, Lewandowski, did show that she was injured. She did pay more out-of-pocket. The problem was that she actually hit her out-of-pocket maximum because of other claims she incurred, non-prescription drug claims. And so the court's reasoning here is that she still would have paid the same amount, right? Whether she was getting these drugs that were overpriced or whether she was paying $40 for these drugs, that she was going to hit her out-of-pocket max anyway. And so ultimately, the court wouldn't be able to redress her claims because she didn't actually overpay ultimately in the end. And so she kind of met 2 out of the 3 prongs of the standing requirement, but still didn't meet all 3. And so the court wasn't able to grant her standing either in that instance. And I think ultimately, though, the more, I think, glaringly obvious issue here is that the claims are speculative, right? That's what Johnson & Johnson's attorneys are saying, is that, go show us that an employee of a similarly situated health plan is paying lower contributions, right, to compare. How do you prove? There's some kind of internal email that they could come up with that would show, Johnson & Johnson executives saying, yes, we are having to depress employee wages because of this, or yes, we have to increase monthly premiums just because we're overpaying for drugs. That kind of a smoking gun wasn't in this case, so not that I saw, at least. So ultimately, I think here, when we talk about the reaction in the industry to this case, I've seen a lot of analysts, I'm not going to name them, of course, but who say, this is a massive victory for employers, never mind about all the fiduciary panic with litigation. I don't believe that's the case here. And Cindy and I talked about this before we met for this podcast, that there were things that could be done to sort of fix this, right? The attorneys representing Ms. Lewandowski, again, don't know who they are, but if it were one of us who maybe is a little bit more in tune with the self-funded industry, you probably would have picked a plaintiff who would not have hit their out-of-pocket max, right? You probably would have picked a plaintiff or you would have found some information about other plan participants on other plans to make sure that you would anticipate the argument that these claims were speculative and say, no, they're not speculative. I know that this individual, my client, right, is overpaying or paying more in monthly premiums than she otherwise would have because I looked at 30 other plans, right, and saw what they were paying. Or actually, one of the other cases the court makes is that there was actually no prescription drug that she was prescribed here that was at issue, right? She was talking about other drugs on the plan. Well, maybe you should find a plaintiff that's currently taking 5 of these drugs that are way overpriced, right? So it just looks like they had the wrong plaintiff here. So to me, that doesn't scream massive employer victory. It screams this case is probably going to be refiled, especially because the claims were dismissed without prejudice by the court, meaning that they're able to be brought again, right? And I fully expect that they will be brought again. And there are other ongoing cases here that are similar in nature to the Johnson & Johnson case. And we don't know yet whether those plaintiffs are any better suited to meet the standing threshold. But we're not out of the woods yet here as an industry, or if you're an employer who is kind of fearful about how much you're paying for prescription drugs. So I don't know, Cindy, if you had any thoughts on that issue.
Right. So at the beginning of the podcast, I said people were touting this as a blueprint. It ultimately was a blueprint that failed, but I think it may, like to your point, may be something that is a foundation that kind of gives them the roadmap to possibly being able to successfully pursue their claims in the future.
Absolutely. Yeah. So, I mean, if we get asked the question by our clients, okay, well, what should we be doing as, employers to avoid the potential for this kind of litigation going forward? So again, in our opinion here, this is still not going away. So what you should be doing is engage in prudent fiduciary decision-making when you select PBMs, right? Look in the marketplace. Right now, a lot's been talked about with regard to spread pricing, for example. A lot of the larger PBMs are engaged in that practice, which is kind of stale at this point. It's where they're effectively overcharging, or they're charging you the spread, the difference between the PBM's cost and to you and the cost of acquiring the drug from the pharmacy. And that's kind of become an outdated practice in the industry. A lot of the more regional PBMs and even the larger ones are starting to shift away from spread pricing because it's unpredictable, because it leads to really high costs. And Congress is very unhappy with spread pricing. So maybe you don't pick a PBM who uses spread pricing, or maybe they minimize the use of spread pricing. Look at your PBM contractor, have an expert in the field. Look at your PBM contracts to make sure that you have good terms that are favorable for you when it comes to PBM rebates, for example. Make sure that generic drugs are handled a certain way. Make sure you're exploring specialty drug solutions. There are vendors out there that allow for carve-outs, right, to handle certain drugs under a certain program that saves the plan money. Just essentially pay attention to what's going on. Don't be flying blind at the wheel, because then you're opening yourself up to allegations that you weren't paying attention as a fiduciary to the cost that you were incurring. I think the only saving grace here, again, aside from the fact that this is going to be harder to meet the standing requirement, is that all plans are in the same boat right now. So everyone's facing this problem here. Johnson & Johnson's not the only one, but what we recommend certainly is that you don't want to be caught flat-footed, that you are engaging in robust discussions, have a track record of the emails you're sending around internally. We're saying, hey guys, what can we do to address our PBM issues and our drug costs? Show that you've done some due diligence. Maybe you don't ultimately succeed and you can't get costs down as much as you want, but if you at least show that you're making an effort, that's what's required as a fiduciary, right? That you're at least trying, and that you're not just blindly paying the spread pricing or the crazy administrative fees or giving up all your rebates. Those, I think, small things can really, really help go a long way and will prevent you from finding yourself targeted. But I think this is, again, a part of a trend that we've talked about at length in earlier podcasts and webinars, where usually it started pretty much in the 401k space, but where you had lawsuits being brought against plan administrators for paying excessive fees, right? And just people didn't feel like they're getting value for the plan assets that they're contributing to their retirement accounts, or in this case, to their health plans. So this is not going away. This is a huge opportunity for attorneys who engage in this kind of litigation. I think they'll keep bringing these cases, and eventually they will find better plaintiffs, right, that will probably pass muster for standing. And we'll be here certainly to help address those concerns and help you implement best practices to avoid that. But that's our take on sort of what's happened recently with this case. Any closing remarks from you, Cindy, about what plans should be doing looking forward, other than working with the FIA group, of course?
Yeah, no, that's always a great advice. Give us a call.
Yeah, absolutely. So hopefully, we'll be watching the other cases that are still going on that are similar in nature here, but we'll bring any updates to you. But for now, on behalf of myself and Cindy Merrell and our producer, Pat the Man Santos, we want to thank you for tuning in to this special edition video webinar, or podcast rather, Empowering Plans. So we'll talk to you all later.